All right, well, first off, my name is Mary Alice Olson. I'm the Senior Vice President of Client Services with Certemy, and I also lead licensing strategy, regulator at heart, for sure. And I'm so excited to be joined by Dr. Elizabeth A. Carter today. We are welcoming her back for her second Fireside Chat, which she is the first person to be on this series to come back again. And it's because she's such a wealth of knowledge and there's so much information that she can provide. So we gave you a preview last time of what we'd be talking about, but just as a reminder, especially for new faces, we're discussing how we can use data to ensure the fair treatment of licensees in the disciplinary process, right? So boards are often accused of not making consistent decisions or maybe not able to explain the why of why they made a decision or sanction someone, for example. And so what Liz or Dr. Carter will be explaining to us today is how you can actually take the subjectivity out of this process by essentially creating a point system. Now I've watered it down too much. Liz can tell you everything. Okay, good. She taught me well. We're actually going to talk for 30 to 35 minutes today, so it's a little bit longer chat because there's so much to cover. As a reminder, especially to our first-time participants, please use the QA feature in the Zoom chat window to submit your questions throughout the presentation, because we'll spend the last 5 to 10 minutes answering your questions. So with that, let me just introduce Liz with her full title. She is the Director of the Virginia Department of Health Professions Healthcare Workforce Data Center, and she is also the Executive Director of the Virginia Board of Health Professions. So with that, Liz, thank you so much. I'm so glad to have you here.
Thank you so much for inviting me. It's always a wonderful opportunity to share what we've been working on for a long time, but this tends to be the sort of the backroom data crunching people's world. But I think it's hopefully be helpful to all the licensing boards because as Mary Alice was noting earlier, you're often sort of like, whatever you decide, you're going to make half the people unhappy, whatever it is. If you find the respondent in violation, well, they're going to be upset. And if you find it the other way around, the complainant's upset. So you can never make everybody happy. So you're not going to do that. But what sanction reference points will do for you is help you figure out a way to know, like, why did you make this recommendation in terms of the sanction? So I'm going to, if you'll hold on for a moment, because I think it is important for us to sort of summarize up front. So I'm going to give you the nutshell of what it is up front and then walk you through how we got to now. And you actually have in your invitation a really good summary, I think, of what sanction references. So it's with the Virginia Department of Health Professions, and I'll explain what that is in just a minute. But this is a research program. The Sanction Reference Point Program does work on an ongoing basis to provide empirically based information and statistical analyses, reporting and scaling of significant disciplinary sanctioning factors. The SRPs do provide written definitions in manuals of the respondent and offense factors and the scaling resulting in points that are then compared against sanctioning thresholds. So that's, in a nutshell, that's kind of what it is. It helps to ensure fair treatment because the boards can look at what has been significant, but also determine, even if it was significant statistically, it may not be quote unquote fair. It may be unwarranted, and you can remove those factors from your ultimate point system. And that's how you get to be fair. So it's kind of cool. You have an empirical way to do that. And so you don't keep things that are appropriate. We also, on an ongoing way, every month, we will monitor the agreement rates with what our sanctioning reference points manual will recommend in terms of the points, and feed that back. And boards can tell us if they don't agree with what we've put in their recommendations, they need to tell us, what is the aggravating or mitigating circumstances. So we actually get feedback on every case if something comes back and it doesn't fit within our ranges. So wanted to let you know that as well. We also work very closely with each of the boards. We want to make sure that what's in those manuals remain relevant and useful to them. So without further ado, hopefully that gives you the nutshell of what we're going to be talking about. I'd like to move on then now to what the Department of Health Professions is in Virginia. It's an umbrella agency. It has 13 licensing boards. And it also has the Board of Health Professions, which we just spoke to just a moment here. The Board of Health Professions is comprised of members from each of the licensing boards. as well as citizen members. We also have two other programs, practitioner monitoring and prescription monitoring. For the Board of Health Professions, if you look in our code, it has several powers and duties. Our primary role is really to conduct independent research and make recommendations to the governor, the secretary, the department director, and the General Assembly on matters that pertain to health professional regulation, agency performance. And here's something that you got to pay attention to, folks. I actually pulled it out of the code because it's scary if you think about it. Okay. Our job, Board of Health Professions, and this dates back to the 1980s, just so you know, actually 70s, to periodically review the investigatory, disciplinary, and enforcement processes of the department and the individual boards. Okay, we can do that. We can look at what they've done. We have to ensure public protection and the fair and equitable treatment of health professionals. Oh my gosh.
How do you do that, right?
Yeah, we do that. Well, by golly, we found a way to do that. But if you think about that, I mean, if you got that in your code, all of a sudden, you know, your legislature said, okay, you guys are going to do that. Wouldn't you have a heart attack? I mean, if you think about it, it's like, what? Oh my gosh, how are we supposed to do this? There are, and for us too. I mean, we've been around since the late 1970s and had our computer systems and standardized since the 1980s. But there are literally thousands of cases. There are thousands of complaints that come in that have to be processed each year. And if probable cause is determined, the cases can be resolved either at a pre-hearing level through documents. There are informal conferences, there are formal hearings, and our board members basically serve as quasi-judicial judges in this as well. So just so you understand that it doesn't go off to another agency to be resolved. But there are hundreds of these that in any given month, and there are meetings that are going on all over the place, sometimes at the exact same time. So how in the world did they think we're supposed to monitor that? And against which yardsticks? You know, how do you assess what is fair? So I mean, I took it quite literally. I'm like that. It's kind of very, very literal. And yes, that's what our law says. So since the 1980s, the Board of Health Professions really has monitored the number of cases, the types of cases, how they were resolved, violation, no violation, all of that. And then, whether it was some advisory letters, or, just the whole, everything that you could think about related to a case. Okay. We have information on cases that were appealed to the circuit courts, for example. So then you can, well, maybe that's something, maybe, there's a procedural problem. Okay. We keep track of that, but that still doesn't tell you, as you're sitting there as a board member, like what should we consider when we render our sanctions? The board doesn't tell you anything about whether a violation occurred or it didn't occur. But if you have violations, yourselves, you'll have findings of fact, which lay it all out, conclusions of law, and then you have the sanction. And there's nothing in that order that tells you how you arrived at the sanction, pretty much for anybody. Go ahead.
I think that's such a good point. And I think just as kind of a backdrop to all of this, something that I keep thinking about is that, most boards handle disciplinary cases on a case-by-case basis. Absolutely. They're not operating based on case precedents, for example. Not a lot of boards have policies and procedures to say, okay, this is the type of sanction that's always issued in this type of case, and then there's also the issue of like different personalities of boards, right? You might have older board members that are influencing newer board members, for example, or a really strong executive director that is incredibly helpful to the process, but is bringing in, well, this is what we did last time on a case in a way that could be biased, for example. I mean, it's just, everybody's working so hard to do the right thing, but you can see how determining the why of why you sanctioned someone the way you did would be so hard to figure out.
Exactly. And usually, as I was mentioning earlier, different ways to resolve the cases that you may have two board members, they don't even see each other and they're coming up with what they think it ought to be. So, I mean, and it changes all the time. So you don't have, the whole board doesn't look at every single case, so that's another thing. So when you blame the board, but despite that, we've had critics back in the late 80s, early 90s, really just actually throughout the 90s, where they were saying, okay, as Mary Alice noted earlier, well, why did they get off so easy, or why is this so harsh on this individual? And worse yet, why is it inconsistent? It seems like Mr. Jones had the same kind of circumstances, but Mr. Smith got a whole lot lighter or harsher kind of thing. So that's scary too. You don't want to be inconsistent. So that that inconsistency makes people believe that there is bias and favoritism going on, and you can't have that. So, and the boards really had no way before sanction reference really to address those accusations. And as you mentioned earlier, it is case by case. So, and again, I think I'll have to say this over and over again. These board members are in a quasi-judicial role. And for us, I don't know how other boards are, but when we render our decisions about your findings of fact, conclusions, law, and saying, it's all the same day. I mean, you're at that session, you're doing that. So you don't even have time to go back and figure out anything else. It's all done right there. And it's usually rendered in a closed session. Okay. All right, and I'm sure this happens with a lot of us, there are lots more attorneys being involved in these administrative cases to help defend the respondent. And, they started seeing, well, people, they go into closed session. Well, I'm not in there. My respondent is not in there. So, but you might have staff and you've got the board members, what are they doing in there? Well, and if they do, as Mary Alice is bringing up, they ask the board exec or other staff, well, what have we done in the past? That's ex parte communication. And it is, no matter what you try, it's still subjective. So they had a point. And we're like, oh, we got to do something with this. We can't have that. Because again, they weren't doing anything wrong. I mean, as far as we know, we couldn't find anything wrong. But again, it's inherently biased because you'll remember, the worst case or the easiest case, last case that you just had and that kind of thing. So anyway, so against that backdrop of those concerns back in 2001, the Board of Health Professions basically directed staff to come up with a research plan to investigate the factors associated with sanctioning. And they actually gave us, I've got a script here, what way they told us to do. Our job is to provide, this has been our Bible for so long here, to provide an empirical, systematic analysis of board sanctions for offenses and to derive reference points for board members and an educational tool for respondents and the public. We wanted everything we could do to make things as transparent and open so that everybody understood what you were doing and why you were doing it. So we worked inside with our staff as well, and just saying, picking everybody's brains, how are we going to do this? We'll figure this out. And they said for any of these sanction reference systems to be successful, they really have to be develop the complete board oversight. So everything we would do with the respective licensing board would have to be an open session, and we would work with them. And, because my board is advisory. Board of Health Professionals is in it. We can't make anybody do anything. Mm-hmm. Not that we would try, but we can. And so you really have to have the buy-in and the just the working together, the collaboration with your licensing board. It's got to be value neutral. It's got to be grounded in sound data analysis, and it's got to be voluntary. Again, we cannot make them do it. There's nothing in our code that allows us to make anybody do anything. So with that as a background, we started off with that. And of course, the aim was never to second guess any board. It really wasn't meant to do that. But we needed to figure out what the yardstick should be. What are those factors that you all think should be? Yeah, go ahead.
Oh, I just had a quick question. So I know that you and I kind of discussed this previously, but just because that you're kind of dealing with something that's just a big unknown of how to even go about, starting this, and administrative law can be the wild, wild west, if you will. I understand that you guys looked at kind of how the criminal justice system, improved the likelihood of fair decisions, I guess would be a way to put it.
She's so good at segueing things for us. Absolutely. Yes, absolutely. I appreciate that. Yes, when you research anything, the first thing you do is you go, okay, what's in the literature? Well, in the administrative world, there wasn't anything in the literature, but yes, absolutely. I knew in the criminal justice system, they have sentencing guidelines. Internet connection's unstable again. I stopped that.
We can see
and so they were grappling with issues.
Paper in your face.
Oh no, we can't do that. Okay, won't do it. But basically, they were in an effort to ensure that they were not being biased in the decisions that they were rendering in terms of sentences, criminal sentences. There was a huge effort done by all the states and of course on a federal level as well to look into how do we find out what the factors were that affected the outcome of a case, how severe a sentence was. And so they undertook a huge series of research projects, and they were able to to meet with each of the, I should say, they met with justices to figure out, what is it you think is involved? And they were able to go through court documents and minutes of meetings and all, you name it, everything they could get their hands on to see what might be involved. And they were able to do a multivariate statistical analysis of those factors that the judges felt were important. And what you do then is then look to see which are statistically significant factors. For example, recidivism might be a factor. If you've been here a couple of times, all right, well, there's that. The severity of harm that's been done to the victim. Those kinds of factors are there as well. But there are also, they found that there were some unwarranted factors. It might be geographic, it might be related to gender, race, ethnicity, a lot of things like that. But by having this as a statistical model, yeah.
Oh, sorry to interrupt. I just want to clarify. When you say unwarranted factors, specifically, you're saying things that people use to make decisions in cases that represented bias. Okay, good. Just want to clarify.
Represented by, or at least something that should not be taken into consideration to render that decision. And that was something that the judges themselves said, oh my gosh, we didn't know, because you don't know until you see the results of these things.
Right.
You have no idea. They're case by case. Remember that. That's important. So anyway, so you're able to remove those unwarranted factors, and you're able to, then they were able to weight them and score them, and the point factor piece that we talked about earlier. And then they also had thresholds. It has to be this many points before someone goes to jail, or, there's a whole, it's like, it goes on for like whole libraries of this kind of stuff. So, and their system is continually monitored as well. So there in Virginia, we have a sentencing commission that's over in our Supreme Court. And they take all these cases all the time, and they see and do the sanctions or the sentences comport with what's in the sentencing guidelines. And again, they have to cite, just like I'm asking my boards to do, let us know if there are reasons why you depart. And so it becomes a living, dynamic, empirically driven process. So I stole from them. Okay, we just stole from them, and just and thank goodness. Yeah, we were fortunate. Actually, one of our statistical analysis contractors had worked on that project when he was first out of school, and so he knew all the statistical things to do and all that. And so it's a company. I'll give them a plug real quick. It's Visual Research Incorporated. It's a small firm, but this is what they lived and breathed as Virginia was working on its own thing. So I said, hey, can you come here and let's pick each other's brains to figure out, could we do this criminal thing in an administrative environment? How would that work? And so I'm very thankful to the leadership of the agency. Through the years, I brought that to them. I said, here's what the law says. We might be able to have a way to help us, figure this out. Anyway, so what we had to do then is we started with the boards that had large numbers of cases, so medicine, nursing, and so forth. And we started with medicine first. And then, of course, just as they did with criminal justice, you have to do a descriptive analysis first. We needed to find out, again, qualitative meetings with the members of the board, our Attorney General's office, the board staff, all those kinds of things, and what might be involved in sanctioning. We found over 100 factors. That's a lot, but anyway, it's all kinds of little things. It could be for dentistry, for example, it's the number of teeth involved in a case. Well, so it's got to be, board specific, the kinds of cases that you have. And we were able then to take those factors. Yeah, go ahead.
And that would be 100 warranted factors. So things that you
this is just 100 factors overall. This is where we started. This is 100 factors. Okay.
Got it.
You figure out whether it's warranted or not when you get the feedback from the boards. They tell you what would be fair and what would not be fair, and do it in a public way. So yeah, and then we were able to just do. We took like last 5 years of cases. We had enough numbers of cases to do that, and we started with medicine first, and then we did what we call a historical portrait to say, okay, here are the things that are related to one another. These are the things that relate to the outcomes, like for example, loss of license, and sometimes we found some factors that they went, oh my gosh, we didn't know. And so you presented those to the boards, and poor medicine, they're so good about this. They'll let me say it. We found, and they didn't know either. When we were interviewing them to begin with, they said, if we're not, if anything is we're not aware of or whatever, it might be that we're not fair to international medical graduates. Maybe there's something we're doing that we don't know, but just stick that in there and see if you can find out.
They were worried that they were bias
They were,
against.
they just, if I'm, they're being good souls, just saying, I don't know, bearing your side. I might be doing that. I don't know. Well, we found out it was actually the opposite of that. They were much more lenient on those. Again, you don't know because it's case by case. It's not going to be systematized. All right. What we did find out that was a little, just a shock to everybody, is it mattered whether or not it was a woman. It mattered whether or not the respondent had been practicing for many years. And it mattered a lot whether or not somebody had an attorney present for the proceeding. So we looked at the minutes too. We didn't just look at the orders and things like that. We went through case files and all that. And everything was just like, oh my gosh, they had no idea. So of course you extract those factors, out of their system. So that, it was an eye-opening thing. And, God love them. They just, we're your guinea pigs to see what we can do here. So I'm very proud.
So just to make sure, just to summarize that a little bit. So you're saying that basically what you found is that if you were a female doctor who had been in practice for a long time, you were more likely to be sanctioned by the board?
Oh yeah.
By the Board of Medicine?
You're more likely to lose your license. We looked
more
at
likely to lose your license.
Okay. Yeah, and if you didn't have an attorney present. So just, put all three of those together because I mean, again,
wow.
And holding other factors constant. So the type of, all those other things constant. So, and we not only with statistical significance, we can also the relative weights of the decisions. How much harm. We actually have scales, and if you ever get a chance to look at any of our manuals, we go into detail about how the weights affected the level of the points that you get. We started with medicine in 2001. It took us until 2004 to get it done. And we got the blessing, God love them, of the Attorney General's office, because we don't have an institutional review board like you would in a university. But we said, okay, guys, did you look at what we're doing? Make sure everything we're doing is okay. So yes. They only allow us to use them, though we can't use them at formal hearings. They don't want us to do that. They just said, just use it for your pre-hearing consent orders and your informal conferences and that kind of thing. Because people have the right to appeal. If you've done something goofy and whatever y'all are doing, because we're the wacky little research people, we don't want anybody to be harmed by that either. So you always have the right to appeal. So it was a win-win. It helped everybody on that. So by 2010, all of our boards, all the way down to audiology and speech language pathology, which has very few cases, but they still have cases, and they wanted their own sanctioned reference. For the boards that had smaller N sizes, first, few cases, what they would do is pattern after some of the other boards. We would look, because we already gone through the larger boards, and you'd see very similar kinds of things that they wanted excluded out of what was in theirs. But again, every single one of these is based on the board's own history, maybe supplemented a little bit by the small boards. Okay, I beat that one to death. All righty. So you always have to stop me. You know that.
No, it's great. It's great, but I'm so intrigued by some of your discoveries in this process, and I know that you found, lest we all believe that females are treated more harshly, that you also found some more interesting information with the Board of Nursing as well.
Yeah. And again, remember this, guys, this is 20 years ago, so don't pick on anybody now. And nobody's sued anybody about anything. But yeah, that again, when they were saying, maybe we're being, if we're harsher, it might be that toward the men. And it's not. In fact, it was the other way around. So, but it's because it's something that you're worried about, or I'm not sure, and it doesn't matter. If we find that it's in there and it's not right, and you don't want it in there, you take it out of what you're going to use as your tool to render your decision. So it automatically is a tool that allows you to be fair. Mm-hmm. So again, that's why it takes that away. And you still, it's voluntary. You don't have to do it. Do your own thing. But again, we go back to that. So, and I just want to make sure that everybody understands as we go through the process of showing them, here's your results. Those normative, we call normative adjustments to remove those extra legal factors. It's all done during public meeting. Everything is wide open, so it's very transparent. And our models, the ultimate models that we have when you finish all this, you're trying to predict within about 70-75% that middle of your normal curve. You want to have sort of your typical cases. What the model with your SRP model has are that for the typical cases. That's why we always ask for information about whether there's mitigating circumstances or ameliorating circumstances. So, but that's where you go. Let's see.
In our boards, I know you mentioned before that you can't, force the boards to use these matrices. But what sort of, I guess maybe compliance is the wrong word, but
it's agreement.
How accommodating are they in terms of using it?
they've been wonderful about using it because, again, it's a tool. Think about it. You had no case history before. You're sitting in that meeting going, well, what do we have? The sanction reference points basically systematizes your case history, the factors that are important. You've got that. There are different worksheets for different kinds of cases as well. So you'll have one kind of worksheet for a standard of care, maybe another one for fraud. Again, it depends on the board's own history, but you have that. And so the people, we ask them to just fill it out, whether you agree with what we have put in the sanctions recommendations or not. Just fill it out and let us know why. So every one of the cases, we get a sheet and we get to look at that. So it's the compliance, and the compliance rate is overall for the whole agency, it's about 80% actually. Some boards it's like 69, and some of them it varies. But because this is another thing I just wanted to just throw out at this too. We do train the board members. We train the public if you're interested in it. We have trained the Bar Association a couple of times on this. And it's evolving. So as you make new changes, which you will do, sometimes you have new professions that come in, or you've got changes in the code itself, in the law itself, where you've got cases that are coming in. For example, here's another thing that came up recently too, just looking at dentistries to update theirs. They had back at the beginning, they had a lot of advertising related cases. And over the last few years, they don't have any at all. So there's no point in keeping a worksheet for that. So that kind of thing. It's gone to other things, but we do the trainings. We have and the cover sheets. The sanction reference points are not used on all cases. So if it's a case, for example, if it's a compliance case from a prior kind of case that you've already had a decision, it's not used for that. It's not used for action by another board. Say if another board takes your license, another state's board takes your license. It just sort of we don't use it for that because it's already got some decisions there. You may have one worksheet or you may have multiple ones, again, depending upon the board, depending on its own cases. We also, you may have instances where there are multiple things that have gone on. Say, for example, you've got a psychologist who has a boundary issue problem and a fraud thing and CE. So don't use, so part of the instruction here to protect the public is the most serious case type is what you must use your worksheet for. So when we train people, you only do one worksheet, but you take the most serious case scenario. So that helps to protect the public as well. So, and
let's ask you about that in general. Just how do you think that these programs, how do you think this translates into protecting the public? I mean, it's certainly incredibly helpful to boards in making consistent decisions. Do you think it translates to the public being better served as well?
Again, I think so. Of course, it's my baby. I think, it's designed to do that. But we do know, we actually did an evaluation of all of them. Once we got all the boards on, we looked back to see were the decisions more consistent over time. They were there, and you knew why. You had neutrality, you had consistency, but you also had proportionality. So if something is serious, you got the points for that. I mean, it wasn't something where you just go, I'm just tired, or he's crying, whatever the reason. We've been through these before. If you've been with boards, those factors don't matter. It doesn't matter if somebody comes in there snarky and mean. If they've just done some simple thing, the proportionality is there. So it helps to guarantee that. It's just easy and it works. And we meet with the respective boards to find out if what do you want to, if you need to update something, is this still working for you? Can we simplify things? We've done things like, because you got to do the math and some of our meetings go on until 10 o'clock at night. We actually have Excel spreadsheets for our, so they don't have to sit here and do the math to figure out the points, that kind of thing. But I mean, well, it doesn't hurt. But again, having the reasons for departure, again, keeps it evergreen. It really informs us on what we should be doing. So that data is there as well. It's not just what's in our computer system, which, by the way, made a lot of difference when we were even figuring out how to do this. We already had what we call priorities, which is a level of severity. Anyway, when the case comes in, we had case categories. It could be standard of care, it could be fraud, it could be inappropriate relations. All kinds. We had those categories already defined for many years. So that was helpful just to be able to pull those things up from that system. And then you supplemented it with your interviews and going through the minutes and going through the files and that kind of thing to get the data, and then feeding it back I'm just going back through this again, feeding it back to the board members and let them think about, what should it be? And then we adjust as we go on. So it is a living, breathing, dynamic research project, but it's applied research because it's ongoing all the time. And it helps to provide this tool that they didn't have at all before. And it's not just something you have to go through big books and try to figure out what was prior case law because you don't have time for that. It's systematized and it's at your fingertips once you learn how to use it.
Oh, absolutely. No, I can see the benefit to not only the public and the boards, but of course the licensees as well, right? Who deserve fair treatment in the process and consistent treatment and as little subjectivity in the process as possible. So, I mean, it just seems like a tremendous program and that's been very helpful in your state.
Absolutely. And we have had instances, this was one of the boards when we first started using it, I suspect it still goes on, where once the Bar Association knew what was going on, they said, well, I know if my client is guilty, we'll presume, no, they're not guilty these days, but if they are, what's the likely sanction? And so often what they were doing is they said, would you all accept a pre-hearing consent order so we don't have to go through this process? Because we know generally what the ballpark will be. Now, we don't say it's 2.5 hours of CE or, we don't do that, but there's broad ranges of categories. So, like, for example, if they've done something really nasty, it's not going to be no sanction. That's not going to happen, but you might get treatment monitoring if it's like, say it's a drug issue the person's got. But anyway, so again, it's still case by case, but the boundaries and the general why behind what those sanctions would be. So that has helped us in terms of that process. And we also, we train our investigators on this as well, so that they know the factors that are important. That helps them to figure out, what are the questions that should be asked. That will help inform the board's thinking about what to do for this set of circumstances that the respondent has either done or hasn't done. But you go to find those factors. You don't look at, who's somebody's second cousin twice removed, and they were, you look at those factors that are that we've determined are significant and meaningful.
No, I can definitely see why, if not the completed matrix, but if the matrix is public, then an attorney or respondent, alleged violator could take a look at that and say, okay, if I'm guilty or if I think my client's guilty, this is kind of how this case might resolve itself. So maybe I'll go to consent agreement instead of hearing. I mean, that's fantastic because we all know how expensive and drawn out hearings can be. Anytime you can go to consent agreement, it's a much easier process. So that's another incredible benefit.
It helps everybody. And again, everything we have is public. It's on our websites. Each board has it under, if you look under, just Google sanction reference points for that board. And there are guidance documents for each board. And we also have it on our Board of Health Professions site. So there's a whole manual that explains a lot of what I just already said. But then for that respective board, here's how you score, which sheet you select and how you score what's there. So, and we, like I said, we provide our training internally to our investigators, our administrative proceedings division, just about anybody that wants to know about it. we do training for them. So. But anyway, so we do think it really does help to get that, again, that proportionality is there. The factors are objective factors. It's not just somebody's memory. And so you don't have that ex parte communication going on.
Right.
And it just makes sense. And like I said, things change over time, so we're able to stay up with that and it's not that painful. It really isn't. Nobody's gotten angry at us or anything else. And we really have, and if, again, the AG's office is right, just in case, and they want to do it at formals a lot of times because, they go on for a while, but this way, about 95% of our cases are resolved prior to having to do a formal anyway. And, if you want to appeal, just appeal to the courts and then they'll deal with it. But then you wouldn't have to fool with us on top of it. But really, if you can get all that work done without having to be without references, I think it's well served everybody. And of course, I'm biased, but
I think you're right. You may be biased, but I think you're right.
They keep doing it. We started in 2001. We're almost 20 years into this, so
it's incredibly.
It's still what I'm updating. Yeah.
It's incredibly impressive. It really is. And I was just looking at the time. We have about 10 minutes left on our kind of extended fireside chat. So we do have a couple of questions that have come in.
Okay.
So we have one from Mark Bringelman, which I call you out, Mark, because I love that you added this. I'm a longtime listener, first time caller. You are a devoted fan to our regulatory fireside chat series. Thank you. So Mark's question is, State laws protect the confidentiality of some information licensure boards already collect. Example, home address, home phone number, social security number. What data that you collect should likewise be protected from disclosure to the public?
Everything that relates to a case that is not in a notice or an order is protected. We don't release anything that's not in those notices and orders. What sanction reference does is that even though we have the factors that go behind all the scenes based upon the confidential data, it is compiled information. It is, it's basically statistical information. So no individual's information is released apart from what's already listed in that notice, like the findings of fact. That's going to be public, and of course the laws that are involved in it. So yeah, I mean, we're not allowed. We'd go to jail for that. We can't.
Right.
We can't release
Right.
There's a whole section. There's a code that says that. Like, no, you can't release that. So no. But this
that question does remind me of kind of another conversation that you guys had about how you were kind of in a unique position to be able to look into the why behind the sanctioning, because it's an umbrella agency, and you were actually able to dig into not just boards, publicly available board sanctions and board minutes, but the actual case files themselves, right?
Yeah, absolutely. Yeah. And again, we're structured that way. We were structured that way because we have a board of health professions with that section of the code that talks about looking at these processes. Well, that gives us entree. And again, yeah, it gives us entree, and it goes nowhere other than, with the boards themselves. Yeah. So it is unique. I would say, whoever's doing this would need something similar in their code to allow them to get into that. And again, preserving the confidentiality is always important. That's going to be under your Privacy Act as well. It's not just going to be in HIPAA, FERPA, whatever law that applies. We'll protect it as well. But yeah, but that doesn't mean the researchers can't get in there and show you the factors.
Absolutely, absolutely. Is there anything, and this relates to a question that was submitted, is there anything that a board can do if they're not part of an umbrella regulatory structure, but just an individual board that they can do to just start the process of developing their own system, or at least ensuring their decisions are a little bit more consistent? I mean, obviously not every board has access to a whole research team, but thankfully you post so much great information online and you're available for training. But what's just kind of like a starting point for a board to start, getting better in the process?
First of all, I mean, I can't emphasize enough how important it is for you to already have it in a database somewhere. A lot of, the kind of cases they are, if you've got any way to indicate the severity of the case, the priorities we call them, outcomes, it may just be, if it's in a paper form, it's going to be tougher. But if you've got your history, if you got all your cases out there, or if you've got staff that can go back and look at your orders. Again, sanction reference is only used on those cases where a violation has been found. So you won't have to go back and look at every kind of case that came by you. But I would recommend looking at over the last 5 years to see what you've been doing, and looking at the kinds of cases that you have. Looking, whatever you can see within the documents that you have or in your computer system, so that it just makes it easier. It's been a platinum mine for us to have the data already there, a lot of the data already there. Not everything, but again, as I mentioned, you had to go to the case files and so forth. But we can tell you, how long it takes us to do certain things, or I'm sorry, but you get the gist of it. And you really do need to have it so you can systematically look at what you're doing.
Yeah.
And I know it's case by case, but figure out a way to categorize what you have. Use your code. Is it a fraud kind of case, or is it an inappropriate relationship kind of thing? How have you categorized and defined the types of cases that you deal with? Find a way to do that. We have that. We separate our patient care cases from our non-patient care case. There's all kinds of ways that you can just look at your data and begin to see, what is the main, and again, the most serious thing is always the most important thing to keep on mind, even though you'll have multiple kinds of things there. I hope I answered that.
That makes sense. And if nothing else, because obviously some of the boards on the call, they have very limited staff. And so if nothing else, at least starting from where you are now, moving forward, right? If you can't go backwards, at least starting to collect more data and in a more streamlined way. And this has been really helpful in terms of what some of those data points might be.
Sure. And I'm happy to share with you what the Department of Health Professions had in the categories that we use. May not work for you. I don't know, because ours is sort of health related. So if you're within a different kind of profession, it may not, but at least there's certain there's certain factors that are just in there that help us keep track, which Board of Health Professionals had to do a long time ago anyway. But yeah, I'm happy to share the categories that we have to see if that's helpful to you.
Absolutely, absolutely. And you mentioned the code earlier. We have another question that came in. Are the sanction point matrices incorporated into regulation by reference? So
No,
okay.
no, they are in our, we have something called guidance documents.
Okay.
Each state's going to have their own thing. They are separate, and they're treated a lot like regulations, but they don't have the power of enforcement. It's simply, this is what the board has adopted, is what we will do routinely. And so you have that, as a sense of that. So it doesn't have to be incorporated by reference in anything else. But you do need to have some way to let the public know where to go find that, your licensees, the public, and all that. And that's how we've done that with ours.
Okay, that makes sense. Okay. And you had mentioned earlier that you do need a certain number of cases in order to kind of develop a matrix like this and have it be statistically relevant. Do you have like a number of at least kind of minimum number of cases that you would need? I know that's probably a broad question.
It is a broad question, and it depends on how many categories of types of cases that you have. It depends.
Gotcha.
But from your good old statistics in college, you got an N size of 16 in each little.
You're right. That's a good point. I do remember that.
16. So yeah, you need. I would say, it's good to have several hundred at least.
Yeah.
Cases before you try to do this. And like I said, some of them are just too small to do that. If you had like 25 cases, you couldn't.
Right.
For that 5-year period. But if you've got 5,000, woo, it's better.
Yeah.
But yeah.
And for those boards that have a smaller number of cases, essentially what you were saying before is that they would just sort of use a matrix that a similar board was using, in a sense?
They referred back. We would share everything as to, this is what, for this kind of case, for example, for standard of care, this is what medicine did with it, nursing, dentistry, and there's a lot of similarity there, even though they were done separate. You see the same factors come up. So yeah, we felt comfortable by the time 2010 rolled around, when the smaller boards were coming through. They were satisfied with using those. And a lot of it's for us, because we're health regulatory, it is standard of care is a big one for everybody.
Absolutely. Yeah. Across professions, right? Absolutely. That makes total sense.
Yeah.
Well, look, we have managed to answer all of our questions, and we're actually doing pretty well on time. So this is, I feel so lucky. I know we all feel so lucky to honestly just get this wealth of information from you. I mean, this is a 20-year-long project, and look at what you've been able to accomplish. I mean, this is incredible information, and hopefully everybody was able to get a few takeaways in terms of how you can improve your your disciplinary process to ensure the fair treatment of your licensees. So Liz, I can't thank you enough. Thank you for coming back and sharing all your wisdom with us. We really appreciate it.
It's a pleasure. Thank you all. I appreciate it. Take care.
Okay. Bye-bye. Thanks, everybody. Have a good day.